Good morning. My name is Caitlin, and I'm from the event manager at the Cambridge Chamber of Commerce. I'm actually taking over Melissa's position while she's on mat leave. This morning, I would like to welcome Tushar Anandasagar, who is an associate at Gowling, WLG's Employment, Labor, and Equalities Group. His practice focuses exclusively on the management side of employment, labor, and human rights and privacy law. Serving clients across all industries, Tushar advises on a broad range of contentious human resources matters, including with respect to onboarding, growth management, policy review, statutory compliance, employment litigation, labor arbitration, workers' compensation, occupational health and safety, privacy, data security, restructuring, and retrenchment. Tushar believes strongly in integrating with management teams, providing them with a comprehensive operations-focused perspective that balances relevant legal, social, and economic factors affecting the modern workplace. Welcome, Tushar.
Thanks so much for having me, Caitlin, and I can confirm that most of what you said is true. Maybe I can start my screen share. Thanks to everyone for joining us this morning. Bear with us just a moment here while we set up. Okay. All right, here we go. So thanks again, Caitlin, for the warm introduction, and thanks to all of you. I see 42 participants today. Unfortunately, I can't see you. You know, at some point, hopefully in the near future, we'll be able to do these types of things in person again. So as the slide suggests, we are going to be talking about some critical, pressing COVID questions, and the primary question being, you know, whether or not an employer or a business can mandate vaccination against COVID-19. And so as we get started, before we kind of key into the theoretical issues that we're going to be talking about, the legal issues we're going to be talking about, we did prepare a couple of poll questions. And Caitlin, I'm hoping that maybe we can put up the poll questions now so we can get a sense for what the attendees today might be dealing with on the ground. Is there any way that we can set that up? Okay, perfect. So here's the first question. You know, this is the key one. Have you implemented a COVID-19 vaccination policy for your business? Couple of options for you there. So we're getting up to 62, 67, 70, still a couple of answers, and pretty even split between yes, already done, or no, we're thinking about it, and a handful that are saying no, we will not be doing so. Okay, maybe we can move on to the next question, Caitlin. So this is question number 2. Have you received any pushback from employees regarding vaccination issues? So this is something that you may be dealing with, regardless of whether you are implementing or have already implemented a COVID-19 vaccination policy. We've had a couple of discussions with clients where staff have taken it upon themselves to say, you know what, I know you haven't said anything yet, but we are absolutely not supportive of this, or we are strongly in support of this, and anything in between. And so it looks like most of the answers are, our staff are generally supportive of vaccination. A couple of them are saying, yes, but we've dealt with it. So just 3 out of the 27. And then, in the middle, we've got yes, but we're not sure what to do about it. And so I think most of our clients that we have spoken with are inquiring about that middle category. We've gotten some pushback. What do we do about it? And we'll do our best to get to that today. And those are sort of the practical side of things. But yeah, more on that later on. Definitely we'll get to that. Can we go over to the third question, please, Caitlin? Have you received any communications from your third-party customers, contractors, municipalities that you're working for that say all of your staff who come onto our premises or are working with us etc., they must be vaccinated. This is something that we've seen in a number of different municipalities in a number of different settings. I think the first one would have been, in the long-term care sector, we had employers that were concerned about meeting the compliance requirements under the respective laws, and they were saying, hey, if you want to deliver X, Y, and Z to our retirement care facility, all of your staff need to be vaccinated because these are the rules that the province imposes on our workplace. So most of the responses, 59%, not too bad. We've got no, haven't received this type of communication, but a good handful, 8 out of the 25 responses say that they have received these types of communications, and we'll get into that a little bit as well. I think we can move past the polls here, Caitlin. Thank you so much for those who responded. Super helpful. And I will click off here. Okay, so with all of those key pieces of information in mind and a good sense of what we're dealing with, we'll talk about a couple of high-level topics today. The first of which is sources of authority for a mandatory vaccination policy. Not necessarily just mandatory vaccination. We'll definitely include some commentary about rapid antigen testing. And stay tuned for that. Building off of that, what are the risks of implementing a mandatory vaccination policy? And then the converse, item number 4 there, what are the risks of no mandatory vaccination policy? What if we just stay silent on the issue? And finally, number 5, we'll talk about types of mandatory vaccination policies that we are seeing as a firm on the ground that are being deployed by legislatures and our clients that are located throughout the country. So, sources of authority for mandatory vaccination policies. And maybe we can take a step back and say, what is a mandatory vaccination policy in the designated high-risk sector? Well, I think the term mandatory vaccination policy is a little bit misleading, because let's look at the long-term care sector example for context. In that particular space, we have seen very recently an announcement that there will be a true mandatory vaccination policy implemented. Prior to that, and for most of the other high-risk sector workplaces, so we're talking about education sector, we're talking about health sector, we're talking about first responders, the daycare centers throughout the province, they have been mandated to implement a mandatory immunization policy. So the policy requirement is mandatory, but the laws themselves don't actually say, oh, you are required to go and inject the vaccine into your staff. The policy requirement is mandatory. And what do those policies say? In most cases, with the sole exception of the long-term care sector, and these are announcements that have just kind of crystallized over the course of the weekend, we're talking about vaccination or disclosure of some form of exemption, or you submit to an educational campaign, and that will meet the compliance requirements. Now, in order to enter those spaces, you then have to submit to regular rapid antigen testing. And so it's not really a true mandatory vaccination policy. If you can see, there's vax or test, and then the sort of overlay of this education session. So those are the high-risk sectors. What are we talking about in terms of I'm not going to say low risk, we're dealing with a pandemic, but the regular risk sectors? Well, we've got a number of businesses that operate outside of these 5, 6, 7 industry sectors where, you've had to deal with public health coming in and saying, hey, positive case and you're shut down, or 2+ cases, 5+ cases, you're shut down for X period of time. These are regular risk workplaces. Well, the laws in Ontario, at least as we currently sit, by and large, don't regulate and they don't mandate that an employer needs to have in place a vaccination policy that deals specifically with COVID-19, deals with these regular risks. It's an elective decision, right? We've seen a couple of public health regulators, right, local health units that have said, it is our strong, City of Toronto is a great example. It is our strong recommendation, but it's not a legal requirement that you implement a vaccination policy for your workplace. And so let's talk a little bit further about the regular risk workplaces, because I think most of our attendees today would probably fall under that category. How do you justify a policy? What is the source of your authority? I think the first one would be the Occupational Health and Safety Act. every precaution reasonable in the circumstances. You as a business, you as an employer, are obligated under the OHSA to take every precaution reasonable in the circumstances to keep your staff safe. Whether it relates to safety boots or masking or stepping up your ventilation in your workplace, these are all justifiable in theory under this general duty clause under the Occupational Health and Safety Act. If we look to pre-COVID regulations that offer some justification in certain sectors, most of which are those high-risk sectors, there are a number of legislative provisions under the regulatory frameworks for daycare and childcare, for paramedics, and for not employment specific, but in public schools, where individuals have to be maintaining a certain level of vaccination or have to prove certain vaccines have been administered in order to access the premises and continue working or studying during a possible outbreak. So this is not really a new issue. It's been dealt with in the past. And, certainly, I've spoken with many of my colleagues who remember, TB or polio or a number of different types of vaccine, MMR, dealing with these mandatory compliance requirements in order to live at a residence and university, walk into a public school, that kind of thing. So we're dealing with issues that are not necessarily brand new. COVID obviously is a little different because we're dealing with this in the context of a pandemic, but the concept of mandatory vaccination is not brand new. And that certainly is something that I think has factored into the province's approach to these high-risk sector workplaces, including the long-term care, education, and the other sectors. In terms of the regular risk sectors, because there's no mandatory requirement, we are trying to justify it looking to these other sources, indirect justification rather than direct justification. And so what if you elect in favor of putting in some kind of mandatory vaccination policy or vaccinate or test or one of these prevailing types of policies? Well, there are risks. There are legal risks, and most of these are new in terms of the interaction of laws between COVID-19 and employment, and all of these different considerations are colliding in a sense, and we're all feeling it. We're all seeing it play out in real time on the news. And so, why is this? Vaccination is an internal medical procedure. It's not like wearing a mask. It's not like filling out a form. It's not like submitting to a rapid test where you swab and then 15 minutes passes and you've got a preliminary positive, negative, or whatever. It's an internal medical procedure. And so when we look at some of the case law that predated COVID, because there's only a small handful of cases that have dealt with COVID-specific circumstances because of shutdowns in the courts and delays and suspensions and all of that. They're affected by the same stay-at-home ordered closures, emergency orders that we all are. To an extent. And so we're seeing that there's a delay, there's this backlog, the law is lagging behind reality as it's playing out around us. So we look to the past. What do we see from the vaccinate or mask cases? 10 years have passed, and over the course of the last 10 years, we have these influenza cases. Not super relevant. To give you one example of something that was considered in the influenza cases, there was one particular case where the union was actually challenging the mandate, the vaccinate or mask part, the mask part of the mandate, saying, oh, individuals will be intimidated by nurses who are wearing masks. And we've done a complete 180 from that particular world. We're dealing with some, intra or during COVID cases. We look at this Crescent Care decision that dealt with mandatory PCR testing. So again, not an internal medical procedure. The arbitrator in that particular case justified PCR testing, saying, nope, it's reasonable to test once every couple of days in order to keep one of the highest risk workplace sectors safe. We have Leuna Local 183 versus Ellis Dawn, and they talked about mandatory rapid antigen testing, which I'm sure you've seen the Chamber's communications. Many of you may have already implemented antigen testing at your workplaces. And effectively, in that case, the arbitrator said, it's a justifiable invasion of personal privacy. It's justifiable under the Health and Safety Act, under the Reopening Ontario Act, to maintain a safe working environment where you've got contractors coming in, inability to maintain full 6 feet, 2 meters physical distance, lots of people attending at different job sites throughout the day, lots of traffic, so to speak. And so employer imposes a mandatory rapid antigen testing requirement, and the arbitrator came in and said, that's reasonable as a temporary measure to deal with the risks posed by COVID-19. And so we don't have a perfect answer in terms of legal risk because, again, courts have been shut down. We're still sort of waiting to see what's happening here. And in terms of the key takeaway, I think something to bear in mind as you go forward is that each employer's ability to justify a mandate of whatever sort, if it's a rapid antigen testing mandate or a vaccine mandate or something along those lines, it's going to vary. We are dealing with this on a case-by-case basis. And so we anticipate, and again, I wish I had a crystal ball, I'd be much better at my job, but the anticipated direction is that the more congregate the setting, the greater the risk of transmission, the greater your ability to justify this type of approach will be. So one of the key things that comes up, I'm going to say 5 times a week, is some form of pushback from an employee or concerns about human rights. Human rights is the hot button issue, I would say, out of this whole stack. And then, we'll talk about some breach of contract risk and whatnot. But I do think that it's important to look at one particular statement that was issued by the Human Rights Commission. So not an adjudicator, not a lawmaker, not a sort of binding legal decision from the Supreme Court or something along those lines. But this particular statement actually comes down in favor of saying it is entirely possible for an employer, a business, an organization to implement a vaccine mandate, right? A mandatory vaccination requirement. And they went on to talk about rapid antigen testing as well, if you see the second bullet point here, in order to contain and deal with the risks posed by COVID-19 on the condition that whatever mandate is imposed, there are duties to accommodate under the Human Rights Code that need to be met. And as long as those protections are put in place, then we are basically, there's no sort of right off the hop immediate violation of the Human Rights Code because you've gone ahead and imposed a mandatory vaccination requirement, right? So, and another piece I think that I want to tease out a little bit about this particular statement is the first sentence right up at the top, which says, while receiving a COVID-19 vaccine remains voluntary. Because something that we see a lot on the ground in terms of pushback from employees is you are jumping all over my rights as a sovereign human. They point to a number of different charter rights. They point to a number of different legal frameworks that may or may not necessarily be Canadian. And so what we'll see is effectively individuals trying to say that you're forcing me to do this. Well, what the Human Rights Commission statement very eloquently states in just a few words is that no one's forcing you to do this. You go and you decide whether or not you're going to be vaccinated. If you choose to get vaccinated, that's your option and that's your choice. If you choose not to get vaccinated, that's your option, that's your choice. In the same way as, if you choose to do 180 in a school zone that's marked 40, that's your option, that's your choice. And so there are consequences associated with your choices, and that choice is yours, it remains voluntary. So the whole, the proposition of, oh, my employer is forcing me to do X, Y, and Z is not necessarily correct. And we are looking at this statement that's been issued by a policymaker. So our thinking is that as we go forward over the course of the next few months and years, this will form a baseline for assessing these types of human rights claims that say my bodily integrity, my rights, you're forcing me to do X, Y, and Z. That first, even just the first line, half the first line over there is super helpful from the standpoint of an employer that is seeking to justify a policy under the Human Rights Code. A little bit more on the accommodation side. We have been looking at all manner of different types of accommodation requests, and I'm sure that you have received a couple of unique ones, let's say, on your side. We do have a handful of medical considerations to keep in mind. One of the medical considerations is myocarditis, pericarditis. These are known, very rare cases. We also have adverse reactions to the first shot. And so, that is a possible medical exemption from a vaccination requirement. But the OMA, the CPSO, the CMA, these are the Canadian Medical Association, they've issued guidelines that say, you know what, there are a very small handful of individuals are actually entitled to this doctor's note that says you are medically exempt from, you cannot receive a COVID-19 vaccine. That is coming straight from the top of the chain at those levels. And so we don't see a lot of the one-liner doctor's notes that you might see if someone's saying, oh, need to be off work for medical reasons, cannot get vaccinated for medical reasons. We have not seen that in the same frequency as we do in some other spaces. Another point on the human rights side is creed, the concept of accommodation on the basis of creed or accommodation on the basis of religious, sincerely held beliefs. We're dealing with some of these on the ground. And I just want to remind employers that, if someone comes in and they send you an email and they say, hey, I cannot because X, Y, and Z reason, and they're quoting something, or they're pointing you to something that suggests that this is a creed-based refusal, you are entitled under the Human Rights Code to scrutinize the individual's request for medical or creed-based accommodation. What does that mean, scrutinize? You can ask them to substantiate it. You can push back. You don't necessarily just have to take it right off the hop and say, oh, tick to the box and off we go. If you're not satisfied with the response that's been received because the person decided last Sunday to join an online church of anti-vaxxers, that is something that you are entitled to push back and actually say, no, I want substantiation. What can that be? A letter from the faith leader, further information. We can go down the chain of possibilities here, and this is all contextual, so case by case. But please bear in mind that you do not have to accept this just at first instance, and you can and you do have the option to push for further information. So we talked about medical reasons, and I'll go through these quickly. One thing that comes up fairly frequently is the concept of this natural immunity. I had COVID-19, 30 days ago. I can't get a vaccine. Even if I get a vaccine, nothing's as good as the natural immunity. The medical community has actually shot that down, to put it in blunt terms. It doesn't cut it for purposes of vaccination, and certainly it wouldn't entitle someone to, for instance, enter a business that's regulated by the vaccine passport requirement. So natural immunity is really not considered the same as vaccinated immunity. We talked a little bit about medical exemptions and how narrow the scope of those exemptions are. We didn't talk about mental health claims, but one thing that's a possibility, and just a specific example, might be phobias associated with vaccination, or phobias associated with needles. So diagnosed mental health issues. We don't see a lot of those, but it's theoretically possible. Good news in that space is that we continue to see new, let's call them delivery mechanisms for vaccines that are being developed, particularly in places where we don't have a fully refrigerated supply chain. And so, you might be able to take a COVID vaccine in a pill form in the near future. So we might be able to get around these phobias, in some point in the future. Excuse me. And we've also got the quote unquote, I put scare quotes around medical notes. My chiropractor says that I cannot get vaccinated because my physiotherapist, my naturopath, you name it. These are not considered medical notes for the purposes of the Human Rights Code. For purposes of vaccination, specifically based on these OMA, CPSO, CMA statements that have been issued to the various medical professions about what vaccine exemptions look like and what they are. So something to bear in mind. And of course, if you have specific cases that you're dealing with, I don't want to cut anyone's grass, but just call. We deal with this a lot. Key considerations on the human rights side, vaccination as a bona fide occupational requirement. So, we talked about the ability of an employer to justify. I don't think we need to go too far there. We talked about the duty to accommodate, particularly where we are dealing with a substantiated, a substantiated medical issue or a substantiated creed claim. We talked about, the duty to accommodate and to work with the individual and have that dialogue and work out whether an accommodation is reasonable in the circumstances. And that leads into the third bullet point, undue hardship. Undue hardship under the Human Rights Code is the backstop for the duty to accommodate. Undue hardship is not established by inconvenience, so it's inconvenience to accommodate, inconsistency, inefficiency, or moderate cost. So there's a high threshold for meeting undue hardship under the Human Rights Code. But and I'll certainly share with the chamber, and we'll have it distributed to the attendees. But that statement by the Human Rights Commission talks about ways to justify and ways to meet the undue hardship threshold. And one of the ways is actually a health and safety exception that is baked right into the legislation that says if an accommodation would result in undue hardship in terms of health and safety risk, then that might be easier to meet, and that might be a reason for a refusal or an inability to accommodate, and it's baked right into the statute. So case by case, but there is an ability to meet that threshold of undue hardship if a specific accommodation would introduce substantial additional risk to the employee or others at the workplace. And then finally, on that side, we talked about the employee's duty to accommodate on the last slide. The employer does have the ability to request additional substantiation and scrutinize the substantiation that comes back. Simultaneously, the accommodation seeker, whether it's an employee or a customer, whoever it is, they do have obligations, and cooperation is one of them. And they have an obligation to cooperate with the accommodation request and meet in the middle and arrive at a reasonable compromise. So we talked about human rights, that ripped through it very quickly. Breach of contract risk. This is something that I would say is probably the next most frequently asked question in terms of vaccine mandates, right? If we're looking at a refusal by an individual and on the assumption that you've implemented a mandatory vaccination policy, a refusal from an individual that says, I have personal reasons, I don't think they're safe. I've done my own research and I don't want to be vaccinated. And you've established a policy that says vaccination by October 30th, something follows after that, right? What is that something? So we look at existing pre-COVID case law. We haven't seen this litigated in the context of the pandemic, but I think most of the cases will be based on an allegation of constructive dismissal. So not an overt termination unless you're doing that, and we'll certainly talk about that. But constructive dismissal, meaning you've introduced a new term and condition of employment which wasn't in place when I first started working, and that change I wasn't consulted on. I don't agree with it, and so that is something that we're starting to see spin up as vaccine policies are implemented in various sectors. Just wanted to flag that the constructive dismissal allegation could come as a result of a number of different strategies or pathways that you go down. So suspension or leave, something that interrupts the individual's pay, that could form a trigger for purposes of a constructive dismissal allegation. Of course, I mean, the termination with or without cause, there are associated considerations that are related to termination. And again, we'll discuss that briefly afterwards. If you put someone on indefinite work from home and you're basically hiving them off from the rest of the workplace, could that possibly ground a constructive dismissal case because they can't interact with their team members and they're coming to you saying, I want to come in, it's safe, I'll be masked, I'll do the antigen testing, etc. What about denial of attendance on customers? We talked about this in the poll questions right off the hop. Individuals who are told that you can't walk onto municipal property because they have a vax passport requirement and you're not able to meet it afterwards. And I mean, I'm not gonna sort of just belabor this too much, but we do not have the same exemptions from PPE as we've seen in some other provinces that have subsequently put the PPE requirements back in place, or the United States of America. Vaccinated, unvaccinated, whoever's coming into that public space and subject to very, very narrow exceptions if you're dealing with employee-only areas where people can constantly maintain 6-foot physical distance, there's generally a requirement to wear PPE, and vaccination is not part of that equation. That equation has nothing to do with whether or not someone has been vaccinated. So PPE is a mandatory thing. But hypothetically, we look, next year after that, hopefully we're not dealing with COVID then, but we're looking. If we're talking about what happens on the back end of this, does a vaccinated person have to wear PPE, whereas the unvaccinated person does not? Could that trigger some form of constructive dismissal because the individual is again claiming that this is not a reasonable requirement? What about, we're all leading into the winter now. What about the Christmas party? Denial of access to corporate social events or differential treatment at corporate social events. These are all considerations that we're starting to work through as these policies are implemented on the ground. And they all sort of fall under this breach of contract, this theoretical breach of contract risk. Another one to talk about is privacy. It's a little bit easier to talk about this in this particular space because I'm assuming that most, if not all, of the 49 participants are attending from the province of Ontario. And unless you're operating in certain sectors, and those would be federally regulated employers in Ontario, there is really no legislative absolute right to privacy as we see in some other provinces. We see this in Alberta, in BC, in Quebec, and there are some ways that absolute right to privacy can be interrupted, and there's some ways that those are dealt with, but we don't consider those as Ontario businesses, employers. We deal with a completely separate regulatory mechanism. There are questions that have been raised. There have been draft pieces of legislation that have been put up before our Parliament, but they have not, they've not lifted up and off the ground. And so currently that is status quo. But we do have these duties as an employer under the common law. And I'll move through this quickly because privacy is I would say lower in terms of the risk analysis, a lower priority item than human rights and breach of contract. But we generally recommend, despite the fact that we don't have legislation saying you absolutely need to do this, mirror the requirements and mirror the compliance steps taken by regulated businesses in other jurisdictions, because that way, if there is legislation that comes into place, we've got consent to collection. Someone has signed off on a consent form. And if necessary, if public health calls on Tuesday and said, I need this record or I need this vaccination data, you've also, if you've got someone to sign a consent form saying, here's my vax record and you can have it and this is what you can do with it, you have authority in writing to disclose. I'll talk very, very briefly about some pre-COVID case law and the right to privacy as it relates to the charter. We talked about some of these wild accusations, allegations that have come out of some of the complaints that employees have sent our way. One of which is based on this sort of inherent right to privacy that's baked into the charter. The Supreme Court considered right to privacy in a handful of cases. One of them was Irving Pulp and Paper that dealt with employment drug and alcohol testing. And so again, not really relevant to the COVID context, but a couple of different things to keep in mind, in terms of the overall framework that could theoretically apply. Is there a reasonable purpose for the breach of this right to privacy? And I'll link back to that Leuna versus Ellis Dawn rapid antigen testing case. The arbitrator said, actually, yes, there is a reasonable purpose and it's stopping the pandemic. So we have hope that, these allegations about charter violations, these allegations about breaches of bodily integrity, based on the initial response that our decision makers that have been sort of dealing with these issues, the recent statements by the Human Rights Commission, the fact that governments are mandating this, we are hopeful that these issues will be dealt with and they will be, handled in favor of businesses that are trying to continue operating. But again, we're all into the theoretical here. And I've smashed a couple of topics into this particular slide. So we'll talk about WSIB, we'll talk about tort as well as sick leave implications, depending on what could happen. So we assume that you're mandating that vaccination is something that is a term and condition of employment. What could possibly happen in the event of a serious adverse reaction affecting one of your staff? The WSIB, they say that if there is, they have a protocol, and I can certainly share some resources with the Chamber to distribute to you. They have a protocol that deals with coverage of vaccination-related reactions, adverse reactions, serious ones, that are arising as a result of a mandatory policy. And so what they're saying is that there's no direct attribution to your specific near statement if you're a WSIB regulated employer for now. And that's something that is going to be assessed across the entire rate group schedule. So something that's hopeful, I think, for at least 2020 and 2021, we are up in the air as to what's going to happen with your possible near statement implications as we look forward into 22 and onward. One thing that is helpful in terms of the WSIB is if you are a WSIB regulated employer and there is this mechanism for dealing with adverse reactions, you may be entitled to a bar to civil claims, meaning that someone can't then commence a parallel court proceeding saying that, oh, I've suffered X, Y, and Z, and you owe me $1 million in damages and all this. So there are a couple of key considerations on the WSIB side, which relate to these serious adverse reactions, not the sort of the more run-of-the-mill, if I can say it, side effects, but we're talking about serious reactions. Tort exposure. Let's assume you run an office workplace, you've implemented the policy, and you have the same situation arise. It's effectively a similar set of considerations, right? We're dealing with what happens in terms of a serious adverse reaction, not the run-of-the-mill, the lower level side effects, and I needed to go to bed for 2 days, that kind of a thing. We're looking at possible tort exposure here, and they would have to check off a number of grounds and heads of they'd have to meet certain legal tests in order for tort exposure to be triggered. Again, case by case, won't get into the specifics here, but that is something to bear in mind. If you do not have WSIB coverage at the workplace, a way to contain that might be to possibly look into third-party insurance, or if you have a sick or disability benefits type approach. And so what happens if someone suffers a serious adverse reaction? You could see STD, LTD, or sick leave claims under corporate policies. And those, again, dealt with case by case, assessed on a case by case basis, but pointing out issues that could come up over the course of the next few months and years. And then the last bullet there is something that I was really hoping would come into effect within this period when vaccines are becoming more prevalent and we're seeing significantly higher take-up and greater supply. Vaccine Injury Support Program. This is something the federal government announced in Q4 of 2020. There were some calls for funding. Effectively, it's a no-fault vaccine support program for individuals who suffer these serious adverse reactions. The hope is that at some point, there's going to be some coverage that takes away these other items over here or possibly reduces them. And allows for this third-party vaccine injury support program to cover employees if they suffer any sort of adverse reaction to a Health Canada approved COVID vaccine. We haven't seen any updates on this particular program for quite a while. It's something that we're tracking and just wanted to sort of plant the seed, and maybe it'll be relevant at some point in the future. So we talk about these risks. We talked about human rights, privacy. There's a lot of discussion of breach of contract issues. What happens if you don't put in a mandatory vaccination policy? Well, I think the approach here really depends on, primarily, I would say, on which sector you're in. If you're in one of the high-risk regulated sectors and you don't have a vaccine policy in place, then you could be looking at penalties under the Reopening Ontario Act. If you're outside of the high-risk regulated sectors and you're in the regular risk sectors, there's no specific clause in the Reopening Ontario Act that says you are liable if you don't implement a policy. But I wanted to point out that there could theoretically be a source for liability, even for your business, if the local health unit, for instance, publishes something that says you as business X, or in response to an outbreak, have to implement this, and you fail to meet that requirement. So that is something that I think that there's a two-step tracking process that I can recommend. First is, keep an eye on the changes to the Reopening Ontario Act. We're constantly speaking on these items. If you're not subscribed to the Gowling Insights section of our website, I'll certainly share the link with the chamber and we'll get that distributed to you. You'll probably hear it there first, but if there's a change to the Reopening Ontario Act that says this is a mandatory compliance obligation for your business, that's something to keep in mind. The second thing is your local health unit. There are so many of them to track for each part of your operations. If they say employers across all sectors, not just the high-risk sectors, have to install vaccination policies, you are obligated to comply, and that ties back to the Reopening Ontario Act, which says recommendations of the health unit, you are obligated to comply with those recommendations, including with respect to masking, bylaws, those class orders that say, hey, you have to report 2+ cases. If you've got 5 or more cases, we can shut you down. Those are all tied back between the Health Protection and Promotion Act, the HPPA, and the Reopening Ontario Act. Another thing that is coming up with some increasing frequency, I would say, is the concept of a work refusal under the Occupational Health and Safety Act. In terms of a work refusal, something that relates to vaccination that we are seeing is that, you know, a vaccinated person is disclosing to you and they're saying that you're vaccinated, et cetera. And then they refuse to work with an unvaccinated person. And they then say that this is a reasonable, you know, reason to refuse work. In our view, and based on what the Ministry of Labor and our health regulators are telling us, that is not a reasonable refusal. But there are steps to take if the employee continues to refuse to come into work. And if you do not meet those steps, the work refusal steps, that is something that could also trigger liability. And you could be looking at a possible labor board claim saying, you know, you did not comply with the statute, you've threatened me, or you know, something along those lines. So also a possible risk to keep in mind if you don't have a vaccination policy. I guess it could also apply if you do. And so I'm moving through this very quickly, trying to save as much time as possible for Q&A. I do see that there's a couple of comments in the chat, but maybe we can just do a quick rundown of the types of vax policies that we are seeing on the ground. So we are seeing, I think, most workplaces that are operating in the high-risk sectors, they're obligated to implement a form of vax or rapid antigen test, so vax or test. These workplaces, they're scheduling these rapid antigen tests, you know, twice a week, unless otherwise required by the regulator that says, you know, you have to do it 3 times a week or a minimum of once a week, something like that. So that's type number 1. The second is vaccination or suspension, a period of suspension, a leave of absence, whatever you want to call it. That is type number 2, and also within the regular risk sectors, probably the most sort of frequently used strategy. And then the third one is your vaccinate, prove vaccination or termination, right? It's vaccination or termination. Effectively, you're out. And you know, there are a couple of different strategies. We spoke about them before. I'll comment briefly on them here. If an employee refuses to participate, and we're not dealing with a human rights exemption, and we're not dealing with a substantiated human rights claim or an accommodation request, then how do we treat that termination? At present, we don't have a case that says, you know, court XYZ reviewed this and they said that this was cause for termination, this was willful neglect of duty, or you're obligated to provide severance to this individual. We're still a little bit up in the air with respect to that. And if we look to pre-COVID case law, for-cause terminations can be justified for failure to meet mandatory health and safety protocols, particularly where they are required, right? I mean, if you've got a mandate from the province and it's baked into the legislation, and it says all staff who are coming on site, they have to wear safety shoes, and this person absolutely refuses, provides no justification, you may be able to meet the high threshold for willful neglect of duty or something along those lines. If we're not dealing with those circumstances, there's a possibility that there could be a severance obligation. And again, we'd have to look at this on a case-by-case basis to figure out how best to proceed here. But I can tell you this, some employers have actually baked into their vaccination policies, especially if they've gone with option 3, that the termination will be falling under either one of these policies, either one of these approaches, excuse me, either a for cause or a willful neglect of duty, or something along those lines, or without cause, and we will pay you out whatever you're owed pursuant to your employment contract. So both of these approaches are happening in real time as we speak, and the law is trying to catch up. Final note here, all of these options are subject to human rights legislation. So we talked about the OHRC's policy statement about, you know, mandatory vaccination, about scrutinizing the substantiation that's provided in response to a request for proof of entitlement to an accommodation. So we talked about that. Those requirements are baked into and really they're overwritten into all 3 of these approaches. And if you are dealing with that type of a claim, I would strongly recommend that you consult with counsel, because there could be significant liability if you're dealing with a substantiated human rights claim and there's a refusal to accommodate and a subsequent termination, including for cause. Most policies that I've seen, and certainly the ones that we've worked on, we will bake in language that says we will comply with the Human Rights Code at all times, and it'll come up in numerous places. I want you to save the date before I flip over to Q&A, and I've just got about 15 minutes here. But what's next? So my colleague, she's wonderful, and I just wanted to sort of plant the seed and have you guys save the date for this. Melissa wrote, she's going to be talking about return to office considerations and what vaccines mean for your business and employees. So the subject matter of this particular presentation has been pie in the sky, theoretical. We're talking about things at a very high level, you know, where the laws are now. But Melissa's presentation, which I think is going to be absolutely fantastic, is going to deal with the practical side. So, you know, what are you going to be doing about your staff members who are pushing back, and what strategies have worked, and how are we communicating? What are we doing in terms of implementation to contain legal risks as these, you know, incidences and pushback and the substantiation letters that say, oh, you're violating the Geneva Convention or whatever are coming in, and you're seeing them in real time. So October 21st, 10 a.m. and save the date, please. And I'm sure the chamber will be circulating more on that. And that will bring me to useful resources. Again, we'll make sure that these are linked and sent out to you. We've got our insight section. You will more than likely hear it there first. We've also got a really helpful article that talks about vaccination policies, despite the fact that it was drafted in December of 2020. It is still relevant today, and it talks about the vaccinate or mask case law that dealt with influenza, as well as the way that that sort of interacts or doesn't with COVID-19. And now, after a lot of yapping, I would love to turn it over. Caitlin, are you able to fire your camera back up? I'd love to turn it over to questions. I believe there's a way for participants to actually speak or ask the questions in the Q&A. I know that there's a couple in there, so I'll stop the screen share, and maybe we can go with the first one. So this is a great question. Can or should an employer ask employees about their vaccination status? Caitlin, this is something that comes up frequently, so maybe I can just take this one right off the hop. I think the can is generally speaking yes. If we look to the Human Rights Commission's question, the Human Rights Commission statements about whether or not a vaccination policy is viable, is legal, doesn't violate the code. This is just one part of it. But we look at that, and it talks about disclosure of vaccination status. The policy can't really exist if the vaccination status is not disclosed, if it's not volunteered and accepted by the employer. On that note, though, if you're outside of a regulated sector that deals specifically with compliance obligations, you have to report what percentage of your employees have been vaccinated as of X date. You can adopt a strategy that may or may not necessarily require you to keep a copy of that vaccination record. And so you may be satisfied with an individual coming in, holding up the phone or screenshot or piece of paper, you name it, and the individual then has proven their vaccination status. Hopefully that answers the question. The reason that I go to maybe not keeping the copy of the record on your side is that it is something that will reduce possible risk in terms of a data breach, in terms of some sort of leak of information or ransomware or something like that. It reduces the likelihood of that happening. And so unless you're required to keep a copy for whatever reason, and the law permits that you don't have to do this, I am a strong proponent of minimal collection of data and sort of leaving as much in the form of an attestation with no identifiable information as possible. We've got a couple of them spinning up. Let's take a quick look here. This is a common one from Mike. Thank you, Mike. So can we ask an employee whether or not they have been vaccinated during a job interview? And I think, if we're looking at this as an extension of a mandatory policy, if you've got a policy that affects your current staff in a certain way, I don't see an issue with pointing out to the person that you're meeting with that we do have a policy in place the policy says X, Y, and Z. These are the compliance requirements. These are the dates on which you have to comply. You can point that out to a new candidate. Now, that new candidate is entitled to the same forms of accommodation if they request it and substantiate it under the Human Rights Code. And so there's really nothing prohibiting you from saying during a job interview, this is something that is our policy, and request confirmation of whether or not that is reasonable. And they can provide substantiation to meet the requirement. Again, you might be looking at some sort of pushback, but I have not seen a lot of that happening. And I know that several of our clients are actually doing this in real time right now. And a lot of the times candidates are happy to just say, hey, look, I've got it. So you may not be looking at a major source of risk here, something that we are seeing happening in real time. Do you recommend small businesses implement vaccine passport requirements for those who do not fall into required sectors? This is a tough one, because we're looking at possible implications that are outside of what's actually been published and is available now in real time. The QR code is not live yet. I know that for purposes of the vaccination passport. And so it's difficult to answer that question because, once we have a full understanding of the QR code system, I think that we'll be able to address that in further detail. Maybe that one might be a takeaway. But going back to that first question, the Vax Passport, the beauty of the Vax Passport is that there is no exchange of information. You're not keeping a record of someone's vaccination status. You're not, they're not sending you a file through some web link or something like that. It's effectively going to function like a gatekeeper in the same way that the compliance form does, in the same way that the masking requirements and the posted signage and the bylaw and all the other stuff that we're currently dealing with do. And so if you don't fall into the required sectors, you do have the option of doing this. But I think we're still waiting for the dominoes and the chips to fall in order to figure out what implementation on the ground is going to look like. Let's see, I think we've got another one here. So a workplace can have different levels of risk for different workers. We have some workers that go into people's homes to provide an energy or water audit. And some of the clients are asking if our evaluators are vaxxed. Others work mostly from home. Is it appropriate to have a different policy for different parts of our work? I think it is. I think it is, because if you've got someone whose role really and truly does not require them to set foot into the workplace, and you're dealing with a strict work from home type arrangement, a lot of policies that we have worked on, we've seen this come up in various spaces outside of our specific clients, published policies by municipalities and whatnot. They actually carve out, they'll say that the requirements apply to individuals as and when they are required to attend on site. And so if you've got some of the clients that are asking about this, and Stephen from accounting works at home, Stephen from accounting may never set foot into the office or into some other space that affects your clients. So if they're saying to you, oh, all of your staff need to be fully 100% vaxxed, I would actually push back and ask for clarification of that and say, well, you know what? The accounting person in British Columbia is not going to set foot in your office or not going to come into your premises. Why is it that they have to be vaccinated? What does this have to do with them? I'd be recommending that in first instance if I was looking at that. Again, depends on the nature of the request, but yeah, generally speaking, there's room for pushback on that. I'm just going to take a quick second. What about vaccination / work from home as a fourth option? See, that is something, Scott, that we talk about in specific circumstances. We don't necessarily see it applied as a general rule. I have yet to come across a policy that says if you can't be vaccinated, you're going to be working from home for the indefinite going forward future. It is not something that has come up on my side, at least. Is it theoretically possible that you could do this? Yes. If the person, we operate in a complaint-based system. So if the person doesn't complain and the employee is okay with this arrangement, they're able to work from home and they're very productive, maybe even more productive from home, this might be a viable option for you. And if you're outside of this regulated sector where you're obligated to do a specific type of policy, then I don't see a reason why we couldn't add that as a fourth option. It's just not the most common. It's not something that comes up and is a common approach that I've seen baked into a policy. It's usually a fallback method if for whatever reason there's there's no way for the individual to come on in. Yeah, I do see. Oh, I've got my colleague Nina on the line here, and she's throwing some links. Thank you so much, Nina. It's super helpful. We're always worry about social media reputational loss if there are rumors of workplace transmission. Absolutely, that's certainly a risk that will come up. You know, there's a lot of coverage of closures. The public health units, local newspapers, they publish a list of businesses that are closed. You know, on a monthly or a weekly basis, and depending on when the outbreak or whatever the incident is that's happened, and that can generate a lot of negative press. Absolutely. So how do we deal with, Scott, once again, how do we deal with parties and banquet halls that require a passport? So that again is a question that relates to something that is going to affect your employees in terms of corporate social events, right? It is an extension of the workplace. If I believe the rule is if they're on paid company time, but I'd have to, don't quote me on that. But how do we deal with these parties? If the venue says that this is the rule, I'm not aware of any way under the Reopening Ontario Act that you can sort of push for that requirement to be waived or relaxed or something along those lines. That I think is likely going to be a backstop in terms of what can be done. If you're looking at a specific mandate and your specific needs to the banquet hall would cause a violation of a mandate, I believe they would simply, they would have no choice but to turn the business away and say, hey, this is the way that we have to operate based on these rules, or we can't operate. You know, we saw this in the initial phases with respect to masking and whatnot, but that is something that is actually playing out in real time, and it is something that you know, you would be able to point to that in discussion with any individuals who are not able to attend at that event, but in theory could possibly trigger legal risk. I don't think it's a high probability. Let's see here. Regarding the risk of not having a vax requirement, client gets COVID as a result. That seems like a big one in terms of the risk. So if you don't have a vax requirement and a client gets COVID as a result, that seems like a big one. That has happened. You know, we've got sectors that have shut down. We've had the Army called into long-term care facilities. There are certain mechanisms and legal frameworks that can limit exposure in these types of circumstances. If, for instance, you're meeting all of the compliance requirements for your specific sector. The legislation is called Bill 218. And so if you're doing your screening, if you're doing your masking, if you know, you're providing the best available types of masks, so ASTM certified medical or surgical grade masks, you'll have an argument against possible liability if the individual says that it came from someone who's associated with your workplace. You've developed protocols that are required for your sector. And again, we don't have a requirement, at least not now, that says that you must put in a vax policy. But MJ, that's a great question. And maybe this last one here, Nina has said, work from home due to vaccine refusal may be seen as rewarding people who refuse vaccines and incentivizing people not to get their vaccine. And many employers want their employees back in the workplace. Absolutely. And I think to Scott's question earlier, that's probably the primary justification. You know, part of the reason why we don't see the vax or work from home as that fourth option. It's something that again is a backstop. It's a sort of case by case, maybe even you know, like a option C or D or something like that. We will look through the chain of available accommodations before getting there. Caitlin, I have talked a lot. Please stop me.
Well, thank you so much. What a fantastic presentation. I just wanted to take a moment to thank everyone for attending this morning's presentation, and that it will be available on our YouTube channel later this week. Thank you so much for your time today, Tushar.
Thank you so much, Caitlin. Thanks for having me, and thanks everyone for attending and for the wonderful questions. Looking forward to the next one.